Hello, everybody. David Serpa with our community here, and today is day 3 of real estate school, this free real estate school that we're putting on, and we're going to talk about civil rights and fair housing laws. I'm going to give you a book recommendation, The Color of Law by Richard Rothstein. Segregation was government mandated, so it's one of those things that we're going to learn a little bit about today. We're going to talk about fair employment and housing acts in California, housing and financial discrimination, Equal Credit Opportunity Act, the Home Mortgage Disclosure Act, and HUD advertising guidelines. But before we jump into that, I've got a special guest for you guys right here in studio with me. And just one second here while I pull up your, here we go. Let's see. Nope, that's not it. All right, so this special guest is Amy Serpa. Amy Serpa, why don't you go ahead and jump in here with me? Dum, 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 dum.
Dun, dun, dun.
Amy is here to talk to you guys about the Commission Boot Camp. And that's it right there. The Commission Boot Camp, which you guys are going to be learning about in week 2. And that's going to be a really big deal. Amy, what should they expect in Commission Boot Camp?
I am so excited to bring you guys Commission Boot Camp. This is something that we've been talking about doing for a long time. I've also been secretly working in the background on some partnerships in the business, which I'm going to keep my lips closed about for now. But we are bringing you guys some major partnerships in the business that will be incredibly advantageous to you to get your business going. So starting January 25th, we're going to kick off Commission Boot Camp, and I'm excited to get you guys going and get you guys paid.
It's going to run daily, Monday through Friday, starting at 10 o'clock. Amy's going to be there probably every day, knowing Amy.
Yes.
And Amy is going to be giving a presentation next week along with Andres Terence Gonzalez and with Zach Bach. And Amy is a combat veteran. She went to Iraq. I'm a combat veteran, and she's also my sister. So, Amy, I'm going to go ahead and kick you right out of the show. Adios.
Adios.
So that is Amy. She's going to be here with us on Monday to give us a little bit more as to what is going on. And then we already told you guys what to expect here with day 3. So we're going to jump in to the boring stuff. Here we go. This actually, civil rights and fair housing is interesting. And it should be given its fair due here. And so here we go. You guys ready? We're ready. Okay. Blockbusting, all the good stuff. Property rights cannot be based on status. Regardless of race, all citizens of the United States have the right to purchase or rent real estate under the Federal Civil Rights Act. Further, all individuals within the United States are given the same rights to make and enforce contracts, rental and lease agreements, sue, be sued, enjoy the full benefits of the law, and be subject to the same punishments, penalties, taxes, and licenses regardless of race or legal status. The Federal Civil Rights Act applies to race discrimination on the sale of rental of all types of real estate, of both residential and commercial. Racially motivated activities in any real estate leasing transaction are prohibited. Federal protection against any racial discriminations given under the Civil Rights Act is a broad protection which applies to the type of discriminations prohibited in all activities between individuals present in this country. Basically, what you're going to learn as you learn more about the history of real estate, the history of real estate agents, is there is a reason why organizations like NARED exist, the National Association of Real Estate, of Realtists, excuse me. And that's because people of color were not allowed to become real estate agents or call themselves realtors. Anti-discrimination in residential property. While the Federal Civil Rights Act provides general protection against all prohibited discriminatory activity, the Federal Fair Housing Act protections are specifically limited to dwellings, including rental housing. A dwelling includes any building or structure that is occupied or designed to be occupied as a residence by one or more families. A dwelling also includes vacant lots offered for lease for residential dwelling purposes, such as lot or space made available to hold a mobile home unit. The FFHA bars the use of any discriminatory actions a seller, a landlord, or property manager might take against prospective buyer or tenant based on an individual's race or color, national origin, religion, sex, familial status, or handicap. Familial status refers to whether a household includes individuals under the age of 18 in the legal custody of a parent or legally designated guardian. Handicapped persons are individuals who have a physical or mental impairment, which substantially limits the individual's life activities or a record of or regarded of having a physical or mental impairment. The term handicap excludes individuals who illegally use a controlled substance. However, alcoholics and individuals who are considered recovering or recovered addicts are protected as handicapped individuals. Now, you're going to find that the National Association of Realtors is really cracking down on discriminatory speech, hate speech. In fact, a lot of brokerages are not even allowing their real estate agents to write what's called love letters anymore, which normally include a picture of the clients and a little bit about their background, because people look at the pictures and then they can make determinations based on a person's race or sex or origin, et cetera, and so forth. And so, my brokerage, eXp Realty, has actually made it so that we can no longer write love letters. And I actually applaud this. I think it's a good thing. I don't even think that names belong on contracts. Qualifying and processing tenants. The FFHA prohibits a seller, landlord, or property manager from unlawfully discriminating against individuals during solicitations and negotiations for the sale or rental of a dwelling. Thus, in the context of leasing, a landlord or property manager may not refuse to rent a dwelling or to negotiate the rental of a dwelling for prohibited discriminatory practices. Reasons. Impose different rental charges on a dwelling for prohibited discriminatory reasons, or use discriminatory qualification criteria or different procedures for processing applications in the rental or dwelling, or evict tenants or tenants' guests for prohibited discriminatory reasons. Different terms, different privileges. Consider a broker who is hired by a residential apartment landlord to perform a property management activity. One of the broker's duties as property manager is to locate tenants to fill vacancies. A tenant from a religious minority group contacts the broker about the availability of an apartment. The broker or their agent informs the prospective tenant of the monthly rent. However, the rate the broker communicates to the prospective tenant is higher than the rent non-minority tenants are asked to pay for similar apartments. When the prospective minority tenant asks the broker for an application, the broker informs the tenant of a non-refundable screening fee is charged to process the application. The creditworthy minority tenant fills out the application, pays the fee, and is told processing will take several days. In the meantime, a non-minority tenant inquires about the rental of the same or similar apartment. The monthly rental rate the broker quotes the non-minority is lower than the rent rate the minority tenant was quoted, even though the non-minority tenant is not as creditworthy as the minority tenant. Further, the non-minority tenant is not charged a screening fee with their application. The apartment is immediately rented to the non-minority tenant. Here, the broker's actions were racially or religiously motivated, a violation of the FFHA. The broker misrepresented the availability of the apartment based on the tenant's religion by using different procedures and qualification standards in accepting and processing the tenant's applications. Selective reduction of buyer or tenant privileges, conditions, services, and facilities offered to protect individuals is prohibited. Selective reduction can take the form of using less favorable provisions in lease or purchase agreements, such as in rental charges or closing requirements, delaying or failing to perform maintenance, or limiting the use of privileges, services, or facilities to different classes of individuals, or refusing or failing to provide services or facilities due to an individual's refusal to provide sexual favors. Further, the landlord or property manager may not discriminate based on an individual's status by representing that a dwelling is not available for rent in order to direct the individual to a particular Section 8 project or neighborhood when the dwelling is available. This practice is called steering. Now, for those of you that don't know, Section 8 is a property voucher that is delivered to people in low-income families that helps them subsidize their monthly mortgage payment. When I was in high school, my mom was a member of Section 8. She got a Section 8 voucher, which made it so that we could live in an area where I could go to school where maybe the schools were a little bit better, despite the fact that my mom was lower income. The program has a 5-year limit. Our limit expired. I actually spent my junior and senior year homeless with my mom and my sisters because my mom could no longer afford to make those payments. So, but when my mom was trying to find somebody to accept that Section 8 voucher, we found that a lot of people did not accept the voucher. And that's called steering, pushing people towards neighborhoods that are, say, less desirable in order to, limit the amount of people that they don't want in their neighborhood. So that's something that I experienced firsthand growing up. So discrimination in advertisement. A broker or their agent making a notice, statement, or advertisement when handling the sale or rental of a dwelling unit is barred from using any wording that indicates a discriminatory preference or limitation against individuals of a protected class of people. The prohibition against prohibited discriminatory advertisements applies to all oral and written statements. Notices and statements include any applications, flyers, brochures, deeds, signs, banners, posters, and billboards used to advertise the availability of a dwelling for rent. Now, this goes to include, this is one of the reasons why when you advertise a property for rent in Facebook, you can no longer choose the age bracket that you're advertising to and things like that. What it does is it makes it more fair, and it doesn't make it so that you're advertising to, say, 18 to 24-year-olds or 35 to 45-year-olds because you think that they're more qualified. Going on. Blockbusting for exploitation. An agent, residential landlord, or property manager may not induce or attempt to induce an individual to offer or abstain from offering a dwelling to prevent the entry of certain classes of people into that neighborhood. This prohibited practice is known as blockbusting. Further, a landlord or agent's actual financial gain is not necessarily to establish a blockbusting conduct. The mere profit motivation is sufficient to establish a blockbusting activity. Examples of blockbusting activities by a landlord or property manager include encouraging an owner-occupant to offer their home for sale or rent by insinuating that a neighborhood is undergoing or is about to undergo a change in the race, color, religion, sex, handicap, familial status, or national origin of its residents, or discouraging an owner-occupant from offering their home for sale or rent by claiming the entry of individuals of a particular race, color, religion, sex, familial status, handicap, or national origin will result in undesirable consequences for the neighborhood or community, such as an increase in criminal activity or decline in the schools or other activities. Now, blockbusting is something that actually used to take place, back in, throughout American history. What they would do is an investor would go and a white investor would buy, because black families were not allowed to qualify for loans in certain neighborhoods, which is part of what that book that I was telling you guys about, The Color of Law, goes into. So The Color of Law goes into how the suburbs were really created, and so black families were not allowed to get loans. And so what would happen is, in certain neighborhoods especially, and so what would happen is a white investor would go into a white neighborhood, they would buy a house, and then they would rent it to a black family, and then everyone in the suburbs would freak out, and they'd be like, oh my gosh, they're moving into the neighborhood, and then they would leave, they would sell their houses because they would be afraid that the property values would go down. So that is called blockbusting, and it's something that people used to do to neighborhoods in order to, they would go in and they would blockbust neighborhoods as investors in order to basically financially benefit off of white flight. There's a lot of really terrible practices that still happen to this day, which we'll go into later in the semester. Okay. Exemptions from prohibited discrimination. There are exemptions to the FFHA prohibitions. A landlord who rents out a single-family residence is exempt from FFHA discrimination prohibitions if they own three or fewer single-family residences, do not use a real estate license to negotiate or handle the tenancy, and do not use a publication, posting, or mailing for any discriminatory advertisement. Thus, the FFHA prohibitions apply to all notices, statements, and advertisements promoting rentals by anyone in the business of renting dwellings. A person in the business of renting or selling dwellings, if the person has participated within the last 12 months as a principal in the 3 or more transactions involving the sale or rental of any dwelling or interest in a dwelling, has participated within the last 12 months as an agent negotiating 2 or more transactions involving the sale or rental of any dwelling or interest in a dwelling, excluding the agent's personal residence, or is the owner of a dwelling structure intended to be occupied by 5 or more families. If a broker is the agent for any of the participants in a sale of a rental transaction, the FFHA anti-discrimination rules apply. However, attorneys, escrow agents, title companies, professionals other than brokers who are employed by a landlord to complete transactions do not bring the transaction under the FFHA unless they participate in the negotiations with the buyer or tenant. Also, exempt from FFHA discrimination rules is the sale or rental of a residence in 1 to 4 unit residential rental properties, which is occupied in part by the owner. Religious organizations who limit the sale, rental, or property or occupancy of dwellings to individuals from the same religion are also exempt, provided the dwelling is owned for non-commercial reasons. No religious exemption exists if the religion is restricted to individuals of a particular race, color, or national origin. Private clubs, which provide their members with residential dwelling space for non-commercial purposes, may limit rental or occupancy of dwellings to members, housing for older persons. Finally, housing qualified for older citizens which exclude children is not considered prohibited discrimination against buyers or tenants with children based on familial status. However, for housing to exclude children, it needs to first qualify as housing for the elderly. A provision in a written instrument which refers to qualified senior housing is enforceable as allowable age discrimination. A senior citizen housing project is housing intended for and solely occupied by persons 62 years of age or older, or intended and operated for occupancy by persons of 55 years of age or older. Failure to comply with the FFHA. Any individual who claims to have been injured by prohibited discriminatory housing practices under the FFHA or believes they will be injured by such practices is considered an aggrieved individual. An aggrieved individual may file a complaint with the Secretary of Housing and Urban Development within 1 year of the alleged discriminatory housing practice. HUD then attempts to resolve the dispute by having the parties enter into informal negotiations called mediation. If mediation is not successful, a judicial action may be initiated by HUD as a complaint to resolve the issue of discrimination. The dispute will then resolved by an administrative law judge. Any party to the complaint may elect to have the claims decided in a civil action before a court of law in lieu of using an administrative law judge. When a real estate broker subjected to judicial action is found guilty of discriminatory housing practices, HUD is to notify the DRE and recommend disciplinary action. When a court determines discriminatory housing practices have taken place, actual and punitive amount of money may be awarded or granted. Also, an order may be issued preventing the landlord or broker from engaging in future discriminatory housing practices. California's UNRRA Civil Rights Act. California's UNRRA Civil Rights Act, another anti-discrimination law, prohibits discrimination by a business establishment based on numerous status qualifications, including an individual's sex, race, color, religion, ancestry, national origin, disability, or medical condition. However, age restrictions is a legitimate discrimination as long as their restriction is in a project that qualifies as a senior citizen housing development. The UNRRA Civil Rights Act applies to anyone in the business of providing housing. Brokers, developers, apartment owners, condominium owners, and single-family residential owners renting or selling are considered to be in the business of providing housing. As business establishments, landlords may not boycott, blacklist, refuse to lease or rent because of the race, creed, religion, color, national origin, sex, disability, or medical condition of an individual or that individual's business partners, members, stockholders, directors, officers, managers, agents, employees, business associates, or customers. Full and equal access granted. Consider a blind prospective tenant who has a guide dog and seeks to rent an available unit in a multi-unit residential dwelling structure. The landlord refuses to rent a unit to the blind tenant, claiming the guide dog violates the building's pet restriction in the covenants, conditions, and restrictions, or CC&Rs. The blind tenant claims the landlord is discriminating against them due to their disability since the landlord denied them housing on account of the guide dog. Here, a landlord may not refuse to rent residential property to a blind tenant because of inclusion of the tenant's guide dog. Landlords are also prohibited from discriminating against tenants with dogs specially trained to assist deaf and other disabled individuals. Now, this is if you live down here in Murrieta, of course, what you do, James, you're going to end up working with a lot of veterans. And where you will see this is there's a lot of veterans that have dogs that help them with PTSD. A lot of, what are those called, Amy? Therapy dogs? A lot of therapy dogs. And so, though that is something that they will go to bat for to make sure that people are able to bring their dogs in. Unfortunately, sometimes these dogs do end up doing some damage, but there's really no way to stand up and say, hey, listen, you can't bring your dog that's helping you not have PTSD into this place. All right. Disabled individuals are protected from discrimination when renting or leasing California residential real estate. A disabled individual is anyone who has a physical or mental impairment which significantly limits major life activities, has a record or disability, a record of disability, or is regarded as being disabled. People with disabilities are entitled to full and equal access to housing accommodations offered for rent. The only exception is the rental of no more than one room in a single-family residence. The examples of the blind tenant and their seeing eye dog illustrate how a landlord might attempt to avoid anti-discrimination laws. While the landlord claims to justify their behavior based on their equal application of a single pet restriction rule to pet owners, an unprotected class of people, the refusal to rent to a disabled tenant based on their reliance on a trained dog is a prohibited discrimination. Accommodating the disabled. A landlord is not required to structurally modify existing residential real property to meet the special needs of disabled tenants. Although not required to modify the structure for a disabled tenant, the landlord is to allow the tenant to make reasonable modifications themselves or pay the landlord to do so. The landlord may require the disabled tenant who modifies the structure to restore the property to its original condition when the tenancy is terminated. Anti-discrimination laws, this would be like a handicap shower or a tub or something like that, putting in handrails, and you will enter into a property where you'll see this sort of stuff. And unfortunately, unless you're looking for a very specific buyer, it does cause the property value to go down sometimes. So you'll see that when people enter into these sort of agreements, normally something says something about returning the property back to its original condition. Okay. Did we just read that? I felt like we just read that. Yes, we did. California prohibitions against discrimination in housing. California prohibits discrimination in the sale of rental of housing accommodations based on the individual's race, color, sex, sexual orientation, gender identity, genetic information, marital status, national origin, ancestry, familial status, source of income, or disability. This list of protected individuals is more extensive than all others. Discriminatory activities and conduct include making a written or oral inquiry into the race, sex, disability, or any other individual seeking to rent housing, ads or notices for rental housing which state or infer preferences or limitations based on any of the prohibited discrimination factors, a broker refusing to represent an individual in a real estate transaction based on any prohibited factor, and any other practice that denies housing to a member of a protected class. The denial of housing based on the landlord or broker's perception that a prospective buyer or tenant has any of the protected characteristics is absolutely prohibited. An individual who has been the victim of discriminatory housing practices may recover their money losses. Now, let me tell you, this is not one of those things. We are not post history. This is not something that is in the history books. You will have people confide things in you that are your tenants that are absolutely, or not your tenants, your clients, that are absolutely disgusting. And sometimes you won't end up wanting to work with them. But sometimes understanding that being a force for good and trying to help people to not discriminate against a buyer that might end up coming into the neighborhood ends up being the best possible thing that you can do. But you're going to hear some crazy things, and you're also going to hear some agents that will confide some crazy things in you. Oh, they're really, right down to they're looking for a family. They really want a family to live here. Well, unfortunately, you can't say that you really want a family to live here. It's not really up to you to determine. You're supposed to just pick the best offer. And so even that is discrimination. All right, income standards for tenants. Standards of conduct applied equally by a broker to all individuals are not classified as prohibited discrimination against a protected group of individuals as they are considered reasonable and thus permitted. For example, to qualify a tenant for occupancy based on their creditworthiness, which is not a prohibited discrimination, a landlord or property manager may establish income ratios or standards to determine a tenant's ability to pay the rent. The higher the ratio of income to rent established by a landlord, the less the risk of loss of rent borne by the landlord. The lower the ratio established by the landlord, the greater the risk of loss of rent. Once set, the ratio is to be applied to all prospective tenants equally. However, two or more individuals who desire to live in the same unit might apply to rent a unit. Whether related or unrelated, married or not, the income of all tenants is to be treated with the total income used by the landlord to determine their collective eligibility to qualify to pay the rent amount sought for the unit. Separately, each prospective tenant may be unable to qualify by meeting the income standard for the total rent sought by the landlord. However, if aggregating the income of all who intend to occupy the unit and enter the rental or lease agreements results in a total income sufficient under the ratio applied to qualify a tenant or tenants for the occupancy, the tenants qualify. Also, rent subsidy programs such as Section 8 housing arrangements, the landlord or property manager will evaluate the tenant's income when determining whether the tenant qualifies to pay based on the only portion of the rent that was not subsidized. Now, unfortunately, what a lot of property management companies do is they will just collect a bunch of fees, $35 fees from a whole bunch of people to apply, knowing that they're only going to choose one. And then what ends up happening is, and I've had people say this on stage, oh, I run a property management department. You get rich in the fees. You get rich in the fees. Charge everybody $35 for an application fee. Leave the applications open for a week and then just choose the best one. And that's the kind of thing that I really detest that's happening right now in real estate that I really want to get out, because $35 is a lot of money when you apply for 10 different places. Okay, familial status. Recall that familial status in anti-discrimination laws refers to whether children under the age of 18 will be living with a parent or guardian on the premises. Rental policies excluding children under the age of 18 are classified as prohibited discrimination under state as well as federal laws under the property qualifies as senior, unless the property qualifies as senior citizen housing, which means that somebody, just like they can't say, I want a family living here, they can't say, I refuse to have somebody that has kids living in this house. Consider a landlord who refuses to rent an apartment to an unmarried couple based on the landlord's religious beliefs about such conduct. The couple files a complaint with California Fair Employment and Housing Commission, claiming the landlord violated fair housing laws that prohibit discrimination based on marital status. The difficult thing about things like this is proving it. Like, you need a text message, you need a paper trail saying things like this. It's very difficult to win these sort of cases. It's also time consuming and costs a lot of money. It's the kind of thing that where, as real estate agents, we need to be nipping these kind of practices in the bud and confronting them when we see them. But, of course, if there's a lawsuit, there's a lawsuit. The landlord claims they're exempt since renting to the unmarried couple violates the landlord's religious beliefs regarding the cohabitation of unmarried couples. However, the landlord's refusal to rent to unmarried couples violates the fair housing laws. The landlord's religious beliefs do not require them to participate in the business of renting dwelling units. Thus, fair housing laws prohibiting discrimination based on marital beliefs do not interfere with the practice of the landlord's religion. The faithful landlord can go into a business that does not violate their religious convictions. All right, guidelines for broker conduct. The DRE, let's see here. Let's see. I actually think we might get our reading done today, which would be great. Okay, guidelines for broker conduct. The DRE has regulations prohibiting discriminatory practices by real estate brokers acting on behalf of a client. A broker of their agent engaging in discriminatory business practices may be disciplined by the DRE. Prohibited practices include any situation in which a broker, while acting as an agent, discriminates against anyone based on race, color, sex, religion, ancestry, disability, marital status, or national origin. Example of discriminatory practices include refusing to negotiate for the sale or rental of real estate, refusing to show property to provide information or steering clients away from specific properties, refusing to accept a listing, publishing or distributing advertisement that indicates a discriminatory preference, any discrimination in the course of providing property management services, Agreeing with the client to discriminate when selling or leasing the client's properties, such as agreeing not to show the property to members of particular minority groups. Attempting to discourage the seller rental of real estate based on representations of race, sex, disability, etc. of other inhabitants in an area. And encouraging or permitting employees to engage in discriminatory practices. Disclosure of disability of other inhabitants. Consider a broker who is licensed, who is a licensed care facility for disabled people, is located in a single-family residence near a residence the prospective tenant is interested in renting. The presence of the facility might influence the tenant's decision to rent the property. However, for the broker or their agents to inform the tenant of the facility would be unlawful discrimination. The broker may not attempt to influence the tenant's decision based on representations of the disability of other inhabitants in the area. Okay, case in point, prohibited discrimination. Okay, so this is an actual case, and this is one of those things that this book is really full of, and so I feel like we might as well read it. An ethnic or religious minority seeks to rent an apartment. The landlord informs a prospective tenant they cannot rent the apartment until they complete a credit check. The landlord also declines to accept the deposit from the tenant. Later that same day, a non-minority tenant seeks to rent the same apartment. The landlord agrees to rent the apartment to the non-minority tenant without first requiring a credit check, and immediately accepts the tenant's check for the deposit on the apartment. The minority tenant is informed the apartment has been rented to the another individual. The minority tenant files a complaint against the landlord, claiming the landlord discriminated against them based on their ethnicity or religion by refusing to rent them the apartment. The landlord claims no discrimination occurred since they were entitled to require a credit check of prospective tenants. However, requiring a credit check of minority tenants, but not non-minority tenants, is prohibited discriminatory practices, which allows the minority tenant to recover their money losses. And this is Stearns versus Fair Employment Practice Commission in 1971. However, and of course, there are several discriminatory practices like redlining. Banks were caught using redlining maps, which is what we talked about earlier in this chapter, as recently as 2012. So this isn't one of those things that's like a distant memory. It's way in the past. This is something that we encourage, we continuously need to confront. However, on a direct inquiry from a tenant, the broker or agent needs to respond based on their knowledge of the existence of a care facility. No duty exists to disclose the prior tenant's affliction with the HIV virus or AIDS. Further, California public policy prohibits a broker from responding to a buyer or tenant's inquiry for disclosure of a prior occupant's affliction with AIDS. Individuals afflicted with the HIV virus are considered handicapped and are protected by the FFHA. Broker's duty to manage employees. A broker has a duty to advise their agents and employees of anti-discrimination rules, including DRE regulations, the UNRRA Civil Rights Act, the California Fair Employment and Housing Act, and the FFHA. The broker, in addition to being responsible for their own conduct, owes the public a duty to ensure their employees follow anti-discrimination regulations when acting as agents on the broker's behalf. So if a broker does not give someone the boot and they're acting in questionable ways, and I've seen several agents get the boot by a broker for doing questionable things or acting in questionable ways, people don't want to get sued. They also don't want to be associated with this kind of stuff because of the kind of money that it could cost them and because it's just bad business, bad juju. And so what will happen is people will actually have their employment terminated. Disclosing a death. An owner, landlord, or property manager will voluntarily disclose the prospective buyers and tenants the death of a prior occupant on the premises which occurred more than 3 years earlier when they have reason to believe the death might affect the buyer's decision to purchase or the tenant's decision to leave. So this is the kind of thing that when you're going through the MLS, the multiple listing service, you'll see these kind of things in the additional notes that somebody has died on the property. Now, I always tell my clients this. There are clients that you will meet, my friend, that when you tell them, hey, listen, somebody died on the property, they don't care what it was. They want nothing to do with the house. They're going to move on. They won't even walk in through the front door. And so sometimes I'll walk in and I'll say, hey, listen, somebody died here, and they're like, well, what happened? And I'm like, it wasn't like ritualistic suicide. There was like 40 people. It's like a natural cause. And a lot of times people will disclose. They'll say, oh, somebody died of old age or X, Y, and Z. And it doesn't matter. You have to disclose it if it happened. always disclose, err on the side of disclosing. Just understand that it will cause some people to not want to buy the house. All right, here we go. Which still makes it the right thing to do. All right. Further, the seller's agent, landlord, and property manager will disclose their knowledge of any deaths which took place on the property in response to the direct inquiry. Consider a tenant who asks the property manager if any AIDS-related deaths occurred on the property. If the property manager is aware of an AIDS-related death occurred on the property, they have a duty on direct inquiry from the tenant to disclose the prior occupant's death and the death was AIDS-related. If the property manager has no knowledge of any AIDS-related deaths occurring on the property, they will disclose their lack of knowledge and whether or not they intend to undertake an investigation to determine if AIDS-related deaths occurred on the property. This has never come up down here, and I don't expect that it ever will come up. Sometimes people will inquire as to how somebody passed away, and I don't ask. Well, sometimes it's held in a trust. Sometimes that information is not available. I just feel like, it's going to bother some people. Other people it won't bother. And, just buy some sage and get over it. Death is a material fact. Consider a property manager who is aware of a death from any cause occurred on the property within 3 years of the commencement of a tenant's lease agreement. The tenant has not inquired of any deaths have occurred on the property. Here, the property manager will need to determine if the death on the property is a material fact which might affect the tenant's decision to lease and occupy the property. The property manager or seller's agent, as good practice, discloses any death occurring on the property within 3 years when they have no reason to believe the fact might affect the tenant's decision to lease. However, on inquiry from the tenant, the property manager discloses their knowledge of any death, including age-related deaths, which occurred on the property within the last 3 years. Okay, if somebody dies, just tell somebody, even if it's been longer than 3 years. I feel like that's just like, basic human decency. So most of the stuff with real estate, if you're a decent human being, you're going to be all right. Okay, we've only got, let's see, 20 more pages and 20 more minutes. I think we're going to make it happen today. Today we feel it here. Today we're going to do it. Discriminatory practices, exemptions, and remedies. Consider a minority tenant who seeks to rent an apartment. The landlord states they will not rent an apartment to a tenant until a credit check has been completed. The landlord declines to accept a deposit from the tenant until the credit has been cleared. I feel like we already talked about this. The minority tenant files a complaint. Was the landlord's conduct discriminatory? Was a landlord's conduct discriminatory? Yes. Prohibited factors. Yeah, we already went over this too. The Department of Fair Housing and Employment, or the Department of Fair Employment and Housing, is the California government agency which enforces anti-discrimination law. Any individual who feels they have been discriminated against may file a complaint against or with the department. The department investigates the complaint to determine any wrongful conduct. If grounds exist, the department then seeks to resolve the situation through discussions with the individual against whom the complaints is made. If the department believes a discriminatory practice has occurred, it will attempt to reach a resolution through the department's mandatory dispute resolution division. The dispute resolution is provided without charge to either party. If the dispute cannot be effectively resolved, the department will file civil action on behalf of the individual who was discriminated against in the country or in the county where the discriminatory conduct is alleged to have occurred. Unlawful discrimination based on familial status. We already know this. Okay. We already read that. Unless the property qualifies as a senior citizen housing. We already read that. Religious exemption. Do not discriminate based on religion. DRE regulation of discrimination. Also enforces numerous regulations prohibiting discriminatory practices by real estate brokers and agents. A broker agent found guilty of engaging in discriminatory business practices may be disciplined by the DRE. DRE prohibited discriminatory practices include situations in which a broker or agent discriminates against anyone based on race, color, sex, religion, ancestry, disability, marital status, or national origin. Blatant discriminatory practices are not as common now as they once were. However, the DRE's focus has now shifted to more subtle forms of discrimination. Implicit discrimination. Implicit discriminatory practices are those which are not openly discriminatory but result in discriminatory effects. A broker has a duty to advise their agents and employees of anti-discrimination rules. This includes DRE regulations, the Unruh Civil Rights Act, the Fair Employment and Housing Act, and the Federal Fair Housing Law. Thus, the broker is not only responsible for their own conduct, but they also need to ensure their employees follow anti-discrimination regulations when acting as agents on their behalf. Chapter 8 summary. Why read it again when we just read it? All right. The Housing of Financial Discrimination Act of 1977. California's fair lending laws. To achieve a healthy state economy. Oh, thanks, man. Sorry, the power shuts off every 2 hours at my office, and I have to restart it. We got it on the switch. Keep the power bill low. To achieve a healthy state economy, all residential housing for sale needs to be available to any home buyer who is creditworthy and qualifies for purchase assist financing. An efficient real estate market requires the value of housing to be immune from fluctuations caused by lenders who arbitrarily deny financing to qualified homeowners. Thus, state law prohibits discriminatory lending practices. The goal of anti-discrimination law in home financing is to increase the availability of housing to creditworthy buyers and increase lending in communities where lenders have made conventional home mortgages unavailable. Okay, there's a lot of first-time home buyer programs. There's a lot of programs out there that are down payment assistance programs. Some are grants that people don't necessarily have to pay off. Some roll it into a rate. There's a lot of different programs out there, and one of the best things that you could do with somebody who they know that they're struggling with credit is first, you can partner them initially with the lender to try to figure out whether or not they actually have bad credit, because sometimes people think they have worse credit than they actually do, and they are already qualified to buy. The second thing is, once you find out that they have bad credit, you could partner up with them with somebody like Tiffany Cross, who works with dedicated credit repair, and they can get to work on fixing that credit. I'll tell you what, if somebody is not ready to buy right now, do not just chase them away. A lot of people say, I only speak to people who are already qualified or already approved. I will continue to talk to somebody until they are ready to go for as long as I need to, sometimes years, because I don't want to give up on somebody. I don't want to give up on somebody. Somebody comes to me and they confide in me the fact that their dream is to own a home. The last thing in the world that I want to do is discount that. I want to make that possible. For me, that becomes the mission, and then the mission becomes critical. And as a human being, as a Marine, if the mission's critical, then the mission must be accomplished by any means necessary. And so, sometimes that means, you don't get paid to open escrows, you get paid to close them. Getting on the phone, figuring out all the different possible ways in which you can make it happen. And that's what I was doing today right before this class, and that's what I'll be doing right after I get done at 5 o'clock, is hopping back on the phone. Okay. Lenders violate public policy when they indicate a discriminatory preference by denying and approving financing to creditworthy mortgage applicants based on the applicant's protected status. In a community which is composed mainly of residents of a certain race, color, religion, or other protected class, a lender may not refuse to fund a mortgage based on demographics of that community. It's called redlining. That's what was happening there for a long time. Appraised real estate in a community at a lower value comparable to real estate in communities predominantly composed of non-minority residents. Again, still happens. You could find articles about people taking down pictures of their family and then the house being appraised for $75,000, $110,000 more. It just happens. Failure to provide financing in certain communities is called redlining. Redlining is specifically targeted for correction by law since it adversely affects the health, welfare, and safety of California residents. I'm going to have you guys watch a video on redlining later in the year as part of the homework, but what I'll do is I'll actually just play it as part of the class. There's a couple of really different things. Great. One is by Roots. It's called Redlining, and the other one is by True TV with Adam Runs Everything, and it's called the History of Redlining. And both of those are excellent videos, and both of them really break this down in somewhat almost comical way that pokes fun at our dark history in this industry. However, a lender can consider, and really honestly, and then if you want, like I said, not just the YouTube video, but you want to dive into it in depth, The Color of Law by Richard Rothstein really flips the whole system on its tail. What's happened is, because of practices like redlining, and I break this down in the information session, but what's happened is black wealth is 10% of that of white wealth in Caucasian communities. The average Caucasian family owns $170,000 worth in their net worth, predominantly through real estate. The average black family is worth $17,000, which is 10% of that. And a lot of that has been due to these practices like what we're talking about right now. Lenders who deny mortgage applications based on characteristics of the community discourage home ownership in that community. Thus, redlining leads to a decline in the quality and quantity of housing in areas where financing is generally unavailable. However, a lender can consider neighborhood conditions when making a mortgage under certain circumstances. When doing so, the lender is required to demonstrate a mortgage denial is based on neighborhood conditions, which render the mortgage unsafe and unsound in a matter of good business practice. Further, if the property's topography, structure, or location is unsafe or unhealthy, the lender is not required to provide purchase assist financing. So that's part of getting a home inspection. That's part of FHA, VA lending guidelines. If a property has Section 1 termite damage, if the water heater isn't double strapped, if there all of these different things, they can determine that the property is unsafe and then not be willing to lend on the property, which is not redlining. It's just smart business because it has to do with the safety and conditions of the house. Notice, and then of course protecting their own asset. Notice of loan applicants' rights. Lenders are required to post in a conspicuous public location at their place of business a written notice informing applicants for mortgages to be secured by an owner-occupied 1 to 4 unit residential property of their right to file a lending discrimination claim and the name and address of the Secretary of the California Business, Consumer Services and Housing Agency. Lenders subject to posting requirements included state-regulated banks, thrifts, public agencies, or other institutions which make, arrange, or buy mortgages funded to buy, build, repair, improve, or refinance 1 to 4 unit owner-occupied housing. Administrative remedies. A mortgage applicant may file a discrimination claim with the agency against a state-regulated lender if the applicant believes their mortgage application was denied due to their race, color, religion, sex, marital status, national origin, ancestry, or any of the other protected classifications described above, or trends, conditions, or characteristics of the community where the real estate is located. A home mortgage applicant who believes they have been unfairly discriminated against by the state lending institution needs to exhaust the agency administrative remedies before suing the lender for money losses. Federally regulated banks and thrifts are not subject to state regulation and discipline. Once the claim is received, the agency will attempt to work with the lender to end any unlawful discriminatory lending practices. The agency will determine if the lender has engaged in unlawful discriminatory practices within 30 days of receiving the complaint. The agency will then serve the lender with the written decision and an order requiring the lender to end the unlawful discriminatory practice. The order will require the lender to review the mortgage application under the non-discriminatory terms and provide the denied financing if feasible. The lender may also be required to pay the borrower's money losses in an amount no greater than $1,000. Okay, Chapter 9 summary. And this is our final chapter. Wait, let's see. Where are we at on this? Oh, we've got 12 more pages. Okay, let's keep going. What happens is I pay attention to this number over here, but the number that we actually need to be paying attention to is this number over here. So that's what's going on. Is we need to get to page 85 today. The Federal Equal Credit Opportunity Act prohibits discrimination and lending based on, let's see, we've already read a lot of this stuff. Okay. Let's see. All right, let's read this last example here. This is probably where we'll end up stopping. Different treatment is discrimination. Lenders need to be careful not to provide more assistance to non-minority borrowers than to minority borrowers when preparing applications and working out problems which arise. The different treatment of minority and non-minority applicants is another form of unlawful discrimination. For example, an African-American couple applies for a mortgage to be insured by the Federal Housing Administration, which will fund the purchase of a residence. The couple seeks to purchase is 75 miles from their place of work. The couple intends to occupy the home as their principal residence and commute to work. The lender suspects the couple wants to purchase the home as an investment and not to occupy it themselves, since the type of FHA insurance sought may only be able to purchase homes that the buyer will occupy. The lender denies the mortgage application. The lender does not discuss with the couple whether they intend to occupy the home. Also, the lender never suggests the couple can apply for a non-FHA mortgage. Due to a mortgage contingency, the couple loses their right to buy the home and incurs expenses in the process. The couple seeks to recover their money losses from the lender under the Equal Credit Opportunity Act, claiming the lender's denial of their mortgage application was due to unlawful discrimination. The lender claims the denial of the mortgage application was proper since it believed the couple did not intend to occupy the home and thus did not qualify for an FHA insured mortgage. There's a lot of assuming that happens in this business that ends up costing people a lot of money in homes, and you really got to cut through the bull crap. You really got to cut through it. Lenders are to provide the same level of assistance to non-minority borrowers as minority borrowers. Thus, the lender may not unilaterally decide the couple did not intend to occupy the home without first discussing the couple's intentions with them. Also, even if the couple did not qualify for the FHA insured mortgage, as a matter of professional practice, the lender needs to refer them to other forms of financing. We've kind of talked about a lot of this here. Denial of credit and and notification. The lender has 30 days to notify an applicant as to whether the mortgage is approved or denied. Alternatively, if a lender does not give the applicant a statement of the specific reasons for the denial, the lender is required to deliver a notice to the applicant stating the applicant has a right to, upon request, to obtain statement listing the reasons for denial. Penalties going against this may cause $10,000. That is that's our 5-minute warning here for class. Let's go ahead and let's see. Is this the last chapter? Is this it? No, we've got 2 more chapters. Okay, let's power through this chapter here. Okay. The Home Mortgage Disclosure Act seeks to prevent lending discrimination and unlawful redlining practices. The HMDA requires lenders to disclose home mortgage or origination information from the public when the borrower is seeking a residential or home improvement mortgage. The state and federally regulated banks and mortgage brokers are required to compile home mortgage origination data. The data is submitted to their respective supervisory agencies. Home mortgage originations include purchase assist financing, construction for a new home, improvement of the borrower's home, or the refinance of an existing home. Federal disclosure requirements. Lenders with total assets of more than $28 million for profit mortgage brokers with total assets of more than $10 million need to compile origination data and make it available to the public. The data includes the type of purpose for the mortgage, the owner occupancy status, the amount of the mortgage, the action taken by the lender on the application, the sex, race, national origin mortgage applicant, and the income of the mortgage applicant. The data is grouped according to the census tracts to determine the lender's activity within the tract. Lender exemptions. HMDA disclosures requirements. If the lender does not have a branch office in the metropolitan statistical area, the lender asset on the preceding December 31st totaled less than $28 million. For-profit mortgage brokers are exempt from HMDA disclosures requirements in the preceding of December 31st. The mortgage broker does not have a branch office in MSA, or if the mortgage broker's asset is totaled less than $10 million and they're originated less than 100 home mortgage purchases in the preceding year. Regardless of exemptions, all lenders approve the Department of Housing and Urban Development, HUD, to report to HUD and disclose the census tract information on all Federal Housing Administration mortgages they originate. The data is compiled by the Federal Financial Institution Council into a disclosure statement sent to the lender. Let's see here. The disclosure statement is required to be posted in a conspicuous location in the lender's office where it is readily available to the public. And we started a couple minutes late, so I'm actually going to keep pushing. We've got 6 more minutes on this recording, so we're going to go 3 minutes over our time into 5:03. If you got to log off, I completely understand, but I want to go ahead and give you as much of this as I can. I'm going to answer your question. Is there any time where a real estate agent or landlord can refuse to sell, buy, or rent with someone? If they are, if they're not a real estate agent and it's them personally, I think it said something about with it being one room, or if it's their home or something like that. But you cannot do it as a business, and you cannot do it as a real estate agent. I believe that that's correct. But if not, let me follow up with. I don't think that there is not any time that a real estate agent can refuse to sell, buy, or rent to anyone based on a class or any sort of protected practice. they can only not decide to rent to someone if the person is not qualified to actually move in. California state regulated lenders. Lenders who originate residential mortgages who do not report to the federal or state regulatory agency are to compile data on the number of dollar amount of mortgage originations for each fiscal year. This includes both actual originations and the completed mortgage applications. State regulated lenders who fall into this category include insurers, mortgage bankers, investment bankers, and credit unions that do not make federally related mortgages. The data is first characterized by geographical area, then by census tract. For each census tract, the mortgage originations are grouped according to the FHA and Veterans Administration mortgage originations on the owner-occupied 1 to 4 unit dwellings. So this actually, this will prevent an FHA loan from being used in certain complexes if there are not enough owner-occupied units. So that's one of those things that when you start showing people apartment units, condos, townhouses, you're going to want to make sure that these areas qualify for an FHA loan. Conventional purchase assisted mortgage originations on owner-occupied 1 to 4 unit dwellings, home improvement mortgages originations on owner-occupied 1 to 4 unit dwellings, and home improvement mortgages originations on occupied 1 to 4 unit dwellings not occupied by the owner. California regulated lenders exempt from mortgage origination disclosures are lenders whose originations of purchase assist mortgages total less than 10% of the lender's mortgage volume during the current reporting year, and licensed real estate brokers who negotiate or arrange purchase assist and home improvement mortgages. Federally regulated lenders are subject to investigation and penalties by federal authorities. While disclosure of mortgage statistics helps to identify lending patterns, mortgage statistics alone are not sufficient to determine whether a lender is unlawfully practicing redlining or other discriminatory practices. The mortgage statistic disclosures may be relevant when considered in conjunction with other evidence. This includes the credit histories of denied mortgage applicants to their debt-to-income ratios. We've got 4 more pages. Chapter 12, HUD advertising guidelines for sales and rentals. Avoiding discrimination and advertising. The printing or publishing of an advertisement for the sale or rental of residential property that indicates a wrongful discriminatory preference is a violation of the Federal Fair Housing Act, FFHA. A property sold or leased for residential occupancy is referred to as a dwelling. The discriminatory preference rule applies to all brokers, developers, and landlords in the business of selling or renting a dwelling. Real estate advertising guidelines are issued by the Department of Housing and Urban Development, HUD. The guidelines and criteria by which HUD determines whether a broker has practiced or will practice wrongful discriminatory preferences in their advertising and availability of real estate services. HUD guidelines also help the broker, developer, and landlord avoid signaling preferences or limitations for any group or persons when marketing real estate for sale or rent. Marketing real estate for sale or rent. The selective use of words, phrases, symbols, visual aids, and the media advertising in real estate may indicate a wrongful discriminatory preference held by the advertiser. When published, the preference can lead to a claim of discriminatory housing practices by a member of the protected class. Words in the broker's real estate advertisement that indicate a particular race, color, sex, sexual orientation, handicap, familial status, or national origin are considered violations of the FFHA. To best protect themselves, a broker refuses to use phrases indicating a wrongful preference, even if requested by a seller or landlord. Words or phrases indicating a preference in violation of the rights of persons from the protected classes include white private home, perfect for newlyweds, Jewish or Christian home, country club nearby, black home, walking distance from the synagogue, ideal bachelor pad, Hispanic neighborhood, or adult building. None of these things are things that you want to use. Preferences are often voiced in judicial colloquialisms and words such as restricted, exclusive, private, integrated, and membership approval. Indicating a preference by age is an exclusion from unlawful discrimination when marketing qualified to 55 years of age or older. Residences or communities. The selective stereotypical use of the media or human models in an advertising campaign can also lead to discrimination against minority groups. The HUD Fair Housing poster. The HUD issues guidelines that require real estate brokers selling or renting single-family residences to display a fair housing poster. The fair housing poster is available at the HUD office. The broker marketing dwellings for sale or rent is to display the fair housing poster in the broker's place of business and in any dwelling offered for sale other than single-family residences. Okay. There is literally a half a page left. We're going to knock it out so that the reading's done and you don't have homework. However, if a dwelling is marketed as a part of a residential development, the fair housing poster is to be placed by the developer during during construction of the development. My goodness. Okay. Of the development. Even though it is required, a broker will not be subject, will not be subject to for failing to display the fair housing poster. However, failure to display the fair housing poster is initially considered sufficient evidence in the lawsuit to show that a broker practiced discriminatory housing practices. Also, a real estate broker and their agents who followed HUD advertisement guidelines and display the fair housing poster are less likely to practice discriminatory activity. The fair housing poster not only openly assures potential sellers, landlords, and buyers, tenants, the broker does not unlawfully discriminate in the services offered. Also, the broker following HUD advertising and poster guidelines is in a better position to defend themselves against a fair housing lawsuit. Use of the fair housing poster indicates to the public the broker's invitation to work with all individuals. Okay, great. That's it for the day. Let's see here. James, you made it. You and me, buddy. So I will see you tomorrow at 4 o'clock for the last boring day. And then Friday we'll have our guided Socratic discussion. And if it's just you and me, then it's just you and me. And then we'll jump into Monday with Commission Boot Camp, and we'll teach you how you can start making some money as soon as possible. Sound good, my brother?
Sounds good.
All right, cool. All right, well, I'm going to go ahead and end this meeting. You have a great rest of your night, my friend.
You too.
Bye.